I'm going to introduce our latest podcast, old friend Brett Vaughn, and we just got back from Vegas. And I will say, certainly the highlight of my week was seeing all of my friends up on the stage at Mass Torts Made Perfect. It brings together people, lawyers from all over the United States. There's a lot going on there, but for those 30 minutes, it's all the people that we work on Covidia and hernia mesh with, and there's a new litigation. Kelsey Stokes, Tim O'Brien, they're co-leads in Covidia, and Caleb, a really great up-and-coming lawyer who's really involved in this project, and of course Brett, who's, in my opinion, the best science guy in mass torts. So tell us what we need to know, Brett.
Yeah, so this new litigation that's getting off the ground is on scopes, and the scopes that we're specifically looking at are for GI scopes, and so your colonoscopies and endoscopies, duodenoscopes, so either going through your mouth or the other end, and these are resulting in sepsis, so a severe infection, and the onset is pretty quick, so we're seeing it within days to weeks, typically after one of these procedures have been done.
The company Olympus, what do we know about Olympus in general and as it relates to Olympus scopes?
Yeah, so Olympus is primarily a camera manufacturer, and so people know them from Olympus cameras. And with scope procedures, there is a camera at the end of the scope, so the physician can see inside of you for whatever they're looking for. And that's how they got into the medical device game. And what they primarily make for medical devices are scopes. And these scopes typically are reusable. The ones that we're looking at for litigation are scopes where they will use them on one person, re-sterilize them, use them on another person, and they're not able to completely sterilize these devices.
How often are these scopes used?
Per year, many tens of thousands of times.
A single scope is used 10,000 times?
Sorry, not a single scope, but there are that many, there are tens of thousands of procedures per year. A single scope can be used for numerous years, and that can be used every couple days.
Generally, a scope is used, and there's some sort of sterilizing process or procedure. And if I'm understanding correct, you believe, and also perhaps the FDA believes, no matter what you do, you can't completely clean this device.
Yeah, and there's been some studies where there have been some outbreaks of very rare organisms causing sepsis in certain locations, and they eventually tracked those back to all the patients having the same scope device used that had been re-sterilized. And they actually went and cultured all these bacteria from the different patients and then did DNA sequencing on that bacteria and saw that the DNA was within like 24 mutations across all these different patients, which meant that it was from the same organism. They then went to the scope that was used on every single one of the patients, sterilized it again, cultured the scope, and it tested positive for, again, the same bacteria that all the patients had. So even after they attempted to re-sterilize it again, knowing that it was likely what was contaminated, they still couldn't get it sterilized properly.
The procedures that we're talking about here are what?
Where a lot of the literature talks about and what we've seen over the years initially is like an ERCP procedure, something where they're going down from the mouth. And a lot of times they'll go into like the bile duct or something. It might be because someone has cancer and that tissue cannot handle like a superbug. And if it's put in that area, you're going to get sepsis very quickly. And that's where a lot of the past literature has focused on this problem. What we started seeing once we investigated this more, though, is it's also happening with colonoscopy. So just routine procedures that someone would have. A lot of people over 40 get recommended to have a colonoscopy. We started seeing that is also resulting in sepsis and a very quick onset sepsis. We struggled with the mechanism of action for a little bit on that one, as did our experts, because you wouldn't normally expect even a superbug to cause sepsis in the bowel, because your bowel can handle quite a bit of stuff. But as we've learned more about these scopes, there's other issues with the scopes that are causing some organ damage in the bowel as well, which we believe is what is giving kind of the nidus or the spot for the infection to take hold, and why we're seeing such high rates of sepsis now.
Have any recalls come out on this, or?
So there have not been recalls specific really to the colonoscopes or duodenoscopes that we were primarily looking at. There have been some advisory comments about moving to single-use scopes as opposed to these reusable scopes, because that would get rid of the risk of infection from one patient to another. Obviously, it's going to cost a little bit more money to do that. There have been some recalls kind of on the periphery of this. Now, Olympus makes a lot of other scopes as well. When they started having this infection problem, again, it's dating back probably 15 years, but they've been very well aware of it over time. They did make some changes in an attempt to fix it. And one of those, there's a cap over the camera. And the cap was permanent initially. Inside that cap is where a lot of this bacteria and debris would accumulate and not be able to be sterilized. And so they changed that end cap to make it disposable around 2020, thinking that you'd be able to take it off and clean it easier. Hopefully that would get rid of the problem. It's still not able to be completely cleaned out, but that disposable end cap we're seeing, whatever it's made out of, it's not holding up in the procedures and it's breaking off inside of people, sharp edges. And that is one of the reasons that you're getting these perforations now. It can also suck tissue in when they're applying suction. For their non-GI devices, so the non-colonoscopes and duodenoscopes, they did recall this end cap on several devices. They did not recall it on this one, though. We're seeing the same problem. That's something we're going to be looking into a lot more through discovery and throughout this litigation.
So is there really any scope that is safe to use, or is this just throughout all of them? There's no way to really get them clean.
That's a good question. Now, they're not all reusable. Reusable scopes are what's mostly used, but there are disposable scopes. So you would use it one time on that patient. That would be the only time you would use it. And that would eliminate the risk. There are other designs that can get rid of this as well, and that are out there. They're not maybe as popular on some of it, where you have disposable aspects of the scope. So instead of the entire scope being reusable, kind of like how they did the end cap. Now, if they would have made the end cap properly, that would have helped some if it wasn't falling off. But there's also just the tubing and stuff like that. If that can be disposable, and it can be, that won't increase the cost as much as having to have the actual camera be disposable. And so there are lots of alternatives that can be done here.
Brett and I have teamed up on a number of litigations, including this one. We've spent, I don't know, hundreds or thousands of hours on the phone talking about hernia mesh and a whole bunch of other litigations. So you can reach out to our firm. You can reach out to Brett's firm. We're going to end up talking about these cases together. Who is it that we should, or that you want to talk to right now while this is an early litigation?
Yeah, who qualifies?
The main thing I'm looking at right now is someone that has had sepsis onset very quickly after one of these scope procedures. And the reason for that is when it comes down to specific causation. And earlier I was talking about how there was this DNA sequencing that has been done in studies that lets us know in general that this is happening and it can happen. But for a lawsuit, eventually we're going to have to do what's called specific causation. And we're going to have to show that this specific scope caused you to get sepsis. And that is much harder to do on a specific case. And in most instances, we're not going to be able to do DNA sequencing to make those links. And in federal court, one of the things that we can use is temporality. And so having that infection onset as close as possible to the actual scope procedure lets us have more arguments to support specific causation. And so I would say that is what I'm primarily looking for right now.
What's the time frame between having this procedure done and then getting sepsis?
Yeah, that's a great question, and one that we were trying to figure out as well, both through the literature and what we've seen come through. And we have seen it within, 24 hours or so, then to start having symptom onset. We see a very large amount of them within days or a week. And that's really where I'm focused on the most right now, is those very quick onset cases.
And is the idea that the bigger the either perforation or place that the bacteria or bad stuff is getting into the body, the bigger the hole, the faster you're going to see?
Not necessarily. It can be a pretty small perforation. But what I was kind of talking with this end cap as well, and I have a video of it where the company's talking about aspects of this, and it's not in the IFU, is if you apply suction with these devices and this end cap is next to the tissue, it's going to suck the tissue inside part of that end cap where it can, and it will damage that tissue. And what I was talking about earlier with that end cap, that end cap is there because that's really where the area that's most contaminated is, and they're trying to fix that. So it's sucking tissue in right where all this bacteria and debris is, basically just impregnating the bowel with that bacteria. And that can turn someone septic very, very quickly. I wouldn't say that the size of the perforation is going to determine it.
IFU are instructions for use for the medical device, is that right?
The IFU, yes. An IFU is the instructions for use.
The IFU, just explain to the people why the IFU matters.
Yeah, that's a great question. It's something I try to talk to a lot of my clients about, because everyone thinks these are simple cases, almost like, I'm not to say a car wreck case is simple, but on causation wise, a car wreck is a lot more straightforward on the chain of events. When it comes to a medical device, these companies have certain protections because they are regulated to some extent, at least by the FDA. And one of the things that we have to show is that if they would have warned a physician properly, that the physician wouldn't have used this device. And that's where the instructions for use come into play, especially legally, is what did the company put in the instructions for use to tell the surgeon or a physician what to be aware of. And so the fact that they did not put in there, in my opinion, how to properly use this device gives us another good attack angle on the company for the failure to warn. That's where we win. I would say the majority of our cases is on a failure to warn basis, not just that it caused your injury, but that the warning would have made a difference to the physician.
These are approved by the FDA. So during these trials to get approved, were there signs of infections going on?
Another good question, and the word approved is really a term of art in the legal field when it comes to medical devices. To say a device is approved, and a lot of physicians would think these types of devices are approved, they are not FDA approved. To be FDA approved, you have to go through called a pre-market approval process, which costs quite a bit of money. It requires studies, kind of like what you were talking about, where you would see these things come about. These were actually cleared and said through something called a 510(k) process. And so as opposed to being approved, they are cleared, which allows them to be on the market. And it's them making a claim that the device is substantially similar in how it functions and the safety profile of a previous device on the market. And so when I was talking about this end cap, they changed from a permanent end cap to a disposable end cap. At most, that was a 510(k) change. Sometimes they don't even have to tell the FDA they're making those changes for that stick to then come onto the market. And so these are not approved devices, even though they're used many, many times a day.
So it's kind of like a loophole.
It's a loophole to get it out very quickly onto the market. And the downside to the company is that it opens them up to litigation. If a product is pre-market approved, actually approved by the FDA, it is considerably harder to bring a lawsuit against them, especially on things like failure to warn and all of this that we are kind of talking about where the base of this liability would be.
So let's talk a little bit about potential MDL, what somebody can expect. The average MDL over the course of the last decade or so is 5 to 7 years. We like to let people know that so there's no surprises. Why do the cases take so long?
That's a good question and one that we get a lot. And especially in this litigation, we are incredibly early. We have not even moved for consolidation yet. We are still building the case out on the early aspects of the master complaint, where we're going to file and everything like that. And then at some point, there will likely be what is called a motion to consolidate, where the judicial panel then looks at the case to see if they can consolidate it or should consolidate in front of one judge. The reason that is done is because so many cases eventually get filed in federal courts that it overwhelms the court system and they can't hear every case or even a fraction of them. So they consolidate them for what's called pretrial purposes. We're going to be getting hopefully millions of documents from Olympus, which is a company in Japan. That takes a lot of time and it takes a whole lot of money for the company to do that. One of the benefits of the MDL is being able to get all those documents. A reason a judge a lot of times in a single case won't give all those documents is a burden. It costs that company so much money to do that for one individual lawsuit. The more lawsuits we have against them in a consolidation, the more that burden kind of shifts with proportionality, and there's a better chance that we can get a whole lot of documents. Again, it takes a lot of time to get those documents, and it takes a lot of time to review those documents, and then we start doing corporate depositions, which again take a very long time. Expert witness workups. All of our experts and their experts are worked up based on the documents and depots we've taken. There's been extensive briefing on all the experts. The judges then have to make extensive rulings on all the experts. The expert phase itself can take over a year after all this other stuff. And then you get to trials. Even though an MDL is meant for pretrial purposes, they take so long to get through and become so complex that that single judge has such a knowledge base that for efficiency purposes, they'll typically do a few trials in front of that judge to see if that settles the whole litigation. Then if that doesn't settle the litigation, they do what's called a remand. They send those cases back around the United States through all the initial judges now that they've been ready for trial, and they either go to trial or that gets things settled. And then the settlement process itself can again take a year or two because of how many cases are filed against them and to work everything through there, liens and just all these other legal aspects to even disperse the money. The litigations take several years. 5 years is not an underestimation at all.
What are some of the things that could affect someone's or any settlement in any case?
there's lots of things that we look at in evaluating this, and it's kind of a constant evaluation that we talk to the clients more and more about as we get later in the litigation and the more we know. But some things that'll make a big difference is just the state in which you reside or were injured in. The statute of limitations on that can be wildly different from state to state, which can be one of the biggest, determinations of your case value. You could have the exact same fact pattern on the exact same day and be in two different states, and the cases are worth vastly different amounts. The causation standard in different states can be completely different from, the failure to warn aspects that I was talking about and what the requirements are there to just causation on, can this be a contributing factor? Or does it have to be a but-for factor where no matter what, this wouldn't have happened otherwise? And those we see when you get to trial and you just through motion practice, cases live and die on that. And so depends on how the cases get resolved, but those things can make huge impacts even if you're incredibly injured.
If a case does go to trial, if there's a bellwether trial, the result of that case is obviously really important. If the product that you had, like in hernia mesh, was the same product that a trial was done on, we have a really good sense of some valuations, or if your injury is similar, that can help drive specific outcomes as well.
Absolutely. I mean, the bellwether trials are huge for us, both sides, in determining values on cases. And it's not even always how much the jury awards or if you win or lose. There's lots of determinations that we're able to make through trial. And just as an example, we've taken some cases to trial before where we knew we had a really low chance of winning, but we needed to get the liability story in front of the defense and in front of the public, essentially. So we went ahead and did the trial anyways. And one of the most informative things was at the end of it, the jury asked, can we give punitive damages even if we don't give specific damages? And the answer is no. So we lost, but it sent a pretty clear message to defense. If we do this enough times, we're going to win.
Aside from the monetary aspect of it, what about making a change? Does this lawsuit potentially open up the FDA to do an investigation and maybe recall these scopes, or have the company change the way that they're making them?
On the FDA side, I don't have a lot of faith in the FDA stepping in to do something. There's been, again, some recommendations on moving to single use previously. The FDA is just, they're very taxed on what they can do. There's a lot of products and they cover everything from devices to food to drugs, and they can't do everything through mesh and everything. There's been surprisingly few recalls on products I think are just horrible that are out there. So I don't see it coming that direction. I do think there'll be a lot of change. One of the things I was talking about earlier is the price difference on a reusable scope versus a disposable scope. The company would love to sell, I would assume, disposable scopes. They're going to sell a lot more scopes. Mm-hmm. Hospitals and insurances probably don't want to pay for disposable scopes because they're going to have to pay more money. And one thing that these lawsuits can do is it can bring the issue to light a lot more, bring it to the risk management, and bring it to the insurance or whoever is counting pennies to make the better decision. I think we see that some even mesh. I was upset some of the meshes haven't been recalled, but you're seeing a bigger pivot by the hospitals and stuff to use a resorbable mesh, and those cost more money. I don't think they have the economic incentive to do it until the lawsuits came. I think you'll see the same kind of economic shift happen there. The other thing I think will happen is I don't think this issue is known enough about it within facilities. And I think a lot of it probably comes down to the same issue I was having and my experts were having of, even if you had a contaminated colonoscope, how is that causing sepsis? Again, you wouldn't expect the bowel to be susceptible to that. And the fact that this end cap is causing, I believe, some damage to the bowel gives us that mechanism of action. I think you're going to see a lot of facilities more aware of it, especially because we're sending letters to these facilities to get medical records or to ask them, hey, what scope was used in this procedure? I would hope that some of those hospitals are sending that on to risk management, and then they're looking to see who all was exposed to the scope. Did they get an infection? And if they notice that they did, then I would expect that their risk management is going to send out, dear client letters, dear patient letters saying, hey, you were exposed to a scope that was contaminated. You should be aware of this. If that starts happening, I think we'll start seeing changes quicker and quicker because I think it's happening all around the United States.
Hopefully some changes will come.
So we're gonna run this one back in a year or two and see where we're at in the scope litigation. But any parting words, things we need to cover that we have not about the scope litigation that you're launching right now, Brett?
I think this has been great. I would tell everyone, both attorneys and patients alike, be patient right now. We are very, very early in this litigation. Just as King was saying earlier, these are very lengthy litigations. This is one of the earliest we've been in a litigation, I feel like, and actually been talking about it publicly. Again, we're pre-consolidation. This is going to take a lot of time. It's a very complex litigation. We're talking about infection and how an infection happened. It's not as easy as an implant that broke while it was inside of you. This is a complex litigation. It's going to take some time, so everyone just needs to have some patience.
We've obviously worked together for a number of years. Our firms who want to talk to you specifically about working together, how should they get in touch with you?
Yeah, I mean, you can reach out to my email. It's online, or call the firm and set up a meeting with me. I'm fairly available on a week-to-week basis.
I would certainly recommend Brett and his firm for smaller firms that want to work with. I would say they're a bigger firm, a lot of skill, but also have the personal touch thing figured out. So if you're looking for someone to work with, I'll personally recommend Brett.
I really appreciate it, and I know my staff loves working with your staff, so I always assume the clients, that's why they're so happy as well, because my staff just loves working with everyone on your guys' side.